education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. My name is Ann Grover, and I'm a principal with the law firm of Joseph Greenwald and Lake. I work in their family law practice. Everyone has heard the term probate, but what does that mean? In our show, we will explore some of the terms and what they mean, how an estate is probated, and some of the common challenges that can crop up. I'm joined tonight by two phenomenal attorneys who specialize in estates and trust practice, administration, and litigation. Jeremy Racklin is a partner at the Bethesda law firm of J.D. Katz, P.C. He manages the firm's probate and trust administration practice. In that capacity, he frequently works with family members of the deceased to open probate estates before the Montgomery County Register of Wills. Once the estate is opened, he assists his clients in administering the estate. Jeremy also represents beneficiaries of estates to make sure that their interests are protected during the probate process. Jeremy received his undergraduate degree in psychology from the University of Maryland College Park and his law degree with honors from the University of Maryland School of Law. He is an elected member of the Montgomery County Bar Association's Executive Committee and a frequent presenter at continuing legal education courses dealing with probate. Jeremy has repeatedly been peer recognized by Maryland Super Lawyer magazine as one of the top 5% of Maryland attorneys in estate and trust law. Reed Spellman is a senior counsel in Joseph Greenwald and Lake's estates and trust practice. He counsels individuals and families in a wide range of estate planning and post-mortem planning issues, including anything from a simple will to advanced tax planning, as well as probate administration, trust administration, and estate tax filings and issues. Reed attended the University of Maryland as an undergraduate and the Catholic University of America's Columbus School of Law. When not working on various estates and trust issues, Reed serves on the board of the Carbon Fund, a nonprofit organization dedicated to reducing carbon emissions. Reed and Jeremy, thank you for joining me.
Thank you.
Thank you.
So Jeremy, what is probate? What does that mean?
Well, first of all, Ann, thanks for having me tonight. So probate is essentially the process when somebody passes away. It is, the best way to think about it is wrapping up the affairs, winding up the affairs of a loved one, of the decedent, marshaling their assets, dealing with any creditors, and administering their estate, distributing their assets either in the manner that's set forth in their will, or if there is no will, distributing the assets in the manner of what's called the law of intestacy, which is a little bit of legalese, but it means what happens where there is no will. And Maryland and all jurisdictions has default rules in place for how assets are distributed where there is no will. So that's probate, the 30,000-foot view.
Okay. Well, Reed, tell me a little bit about a will. So what are some of the rules that are required for having a will that we'll say the Montgomery County Register of Wills will actually administer?
Will needs to be in writing. It needs to have certain provisions. If you want it to set forth who you want to be your personal representative, who you want to stand in your shoes and represent your interests once you're gone. You want it to describe or elicit where you want your assets to go, who you want to receive what you've collected over a lifetime. As far as formalities, it needs to have two witnesses. They need to witness you signing it. Well, actually, I take that back. You need to witness them signing it. They need to be in the room. Everyone needs to stay in the room at the same time. And that's pretty much it. It doesn't have to be a very complicated document. It can be, and depending on what you own, what you have, what you want it to do, there are many layers that you can add to it, but there's no requirement that it be a large novel of any.
Okay. Well, let me ask you something. Everybody has been in a hospital or had a loved one who's been in a hospital. Can you execute a will if you're, we'll say, sick and in a hospital?
I'll take it. I mean, like many things in the law, it depends. It depends upon whether or not you have a sufficient understanding of the object of your bounty, in other words, who you're leaving things to, and the nature of your bounty, what assets you are actually distributing. The capacity to make a will is, it's really the moment that your pen hits paper, that's the litmus test. And, there have been cases where, and it's heavily fact specific, but, folks who have dementia, who suffer from dementia, have good days and bad days. And there have been, plenty of folks who have dementia who execute perfectly valid wills, provided that they have capacity at the moment that pen hits paper. So to answer your question, if somebody's sick and in the hospital, it may actually be the most important time for them to do so, provided, of course, that they have the capacity to do so, to understand who they're leaving things to and what they're leaving, the nature and object of their bounty.
Okay.
If I
And
could add something real quick.
Of course.
As far as logistics, hospitals can be cramped, can also be a very difficult place to find a witness. It's important for if the will is going to be signed in the hospital, that everyone all the witnesses and the testator, the person signing the will, need to witness each other sign. So there have been occasions where a sick individual in the hospital signs, the two witnesses take the document into another room, then they sign it, they saw him sign it, but they actually signed the document in another room. Technically that's not valid. So, or you find one witness and then they need to find somebody else, that witness leaves. It can be very confusing, it's a very traumatizing time. So it's important to make sure that the formalities are met even in a hospital.
Okay. And springboarding on that, Jeremy, if let's say you've got someone with dementia and they've got good days and bad days, are there any things people should look out for or do to try to solidify that the person was having a good day, that they understood exactly what they were doing?
There are certain ways that somebody can bulletproof their estate planning, as I like to put it. First of all, we start with the presumption that a will that meets all the formalities is a valid will unless somebody actually goes to court and has the will set aside. So you start with the presumption, actually, that a will is valid and was signed by somebody with capacity. Now, how do you buttress that? How do you make sure that that stands the test of a possible challenge? Some folks go to the extent of having a doctor sign a note or certify contemporaneously with the will being executed as to the person's mental state. But oftentimes what it comes down to most, quite frankly, is the testimony of witnesses who are there to testify as to what the person's state of mind was. Oftentimes, in our office, when we have individuals execute estate planning documents, we'll ask them some basic questions at the time they sign the will, just to make sure that, and certainly we're not doctors, we're not competent to talk about or testify to mental competency, but there are certain things that you kind of want to look out for when somebody's executing a document, to make sure that they are having a moment of lucidity, a moment of competency, so that will can sustain a possible challenge.
Okay. And Reed, let me ask you, as far as the witnesses that you've talked about, can you be a witness if you've got an interest, if the person who is writing the will is leaving you something?
Can you? Yes. Should you? Probably not. A witness who is named in a will isn't as secure a witness as someone who has no interest in the terms of the will. However, the Maryland law requires that we have two, and if all you have at that point in time is someone who's interested and someone who's not, you take what you have. But definitely, if you can find someone who's doesn't take under the will or has no interest in the will whatsoever, a much better witness potentially down the road if there is a challenge.
Okay. And Jeremy, let's move on a little bit to probating an estate.
Sure.
What does that really mean?
So probating an estate, essentially what it means is visiting the Register of Wills in Rockville. The Register of Wills office is on the 3rd floor of the courthouse at 50 Maryland Avenue. And you'll go there, and you don't have to make an appointment. You'll want to complete some papers in advance. You'll want to complete a petition for probate. That's actually the petition that the person who wants to be the personal representative, and I want to step back a second. A lot of states use the term executor. In Maryland, we use the term personal representative. That's a person that's in charge, that's representing the interests of the deceased. So you'll go to the Register of Wills with your petition for probate that will ask for certain information as to whether or not there's a will, basic questions about, just the rough assets of the estate. You'll need to bring a list of interested persons. Those tend to be legatees, in other words, somebody who's named in a will, or heirs if there is no will. You'll need to post a bond. Even if the will waives a bond, you'll need to post what's called a nominal bond, which is a little bit of an expense, but not a significant one. You'll obviously need to bring the will, if there is one, the original will. And of course, a death certificate. A lot of times that's the most significant document that people actually forget about because they're so wrapped up in whether or not there's actually a will or whether or not the will meets the formalities that you forget the actual document that you need to prove to the register that the person is deceased. But you'll go there and you'll file those papers and an estate will be opened. And then at that point you can begin the probate process.
Okay, so as the personal representative, let's assume that you find out that you're the personal representative because you take a look at the will, and that's the first you see. What do you need to gather, Reed? What documents or information do you need to try to get before you march on down to the Register of Wills?
Well, as Jeremy pointed out, some of the documents that they're going to need in order to open the estate and have you appointed as the personal representative: death certificate, original will, if there is one, other information that you may have access to at the time, assets, documents that you would use to determine whether the assets belong to the decedent alone or whether they were joint. Because if they're joint, they're not part of the probate process. Life insurance policies that have a beneficiary, that's not part of the probate process. If it does not have a beneficiary, or its beneficiary is the estate, that will be part. So if you have access to those items at the time, if it's early, if the decedent passed away a day or two or a week before, you may not. But if it's been a while, those records may be available. Deed to a car. That's not deed to a title to a car. The other thing is the forms that Jeremy referenced are available online, so it may be helpful to actually go to the Register of Wills website, download the forms, complete what you can before you go, or at least know what they're going to ask. Another thing that may be helpful, depending on who the decedent is, if it's a parent or someone, a close lineal relative, the interested persons might be relatively simple to determine, kids, sibling. But if it's great Uncle Joe, it may be that you haven't spoken to half of the heirs. So a family tree of some sort may, depending on the circumstances, be helpful because they're going to want to know the names and addresses and the relationship of all the potential heirs.
And if I could jump into one thing Reed said, a lot of times when I first consult with folks who, and I'll use the classic example of a wife or a husband whose spouse has passed away, a lot of folks are surprised at how little can actually be included in the probate estate. Probate is really only to administer assets that can't be administered in any other way. So any assets, a bank account, for example, that's titled jointly, that doesn't have to go through probate because under the law, upon the death of the first account holder, it just passes by operation of law to the second account holder. The same thing with a house. Probate, just to highlight a point Reed said, probate is really only geared towards assets that either the decedent held in his or her own name or insurance policies, accounts where the beneficiary designation, we all fill out paperwork when we're creating accounts, and it's actually a beneficiary designation, what happens if we die, where the beneficiary designation either is incomplete or the beneficiary designation says, I want my estate to handle this. So quite frequently, I have clients who are surprised at how little actually has to go through probate. Now, that doesn't mean there are other things that they're going to have to focus on, such as final tax returns and things of that nature. But a lot of times there's not as much that's actually subject to probate as people think there's going to be.
Okay. So once the estate has been open, what happens? Let's say that it is your great Uncle Joe and he's passed away and poor Uncle Joe never did get married. So what happens with, let's say, the mortgage on his house?
Someone has to, well, the estate is now stepping into great Uncle Joe's shoes. The person representative's, one of the person representative's duties is to round up the assets and marshal everything and to protect them. If the house has a mortgage on it, that needs to be paid, because otherwise the mortgage company is going to foreclose on the property and take it, take possession of it, which would be removing assets from the estate. One of the problems that results, as Jeremy was talking about, is that the bank accounts are all joint or have a beneficiary, but the house doesn't, but the house has a mortgage. How are we going to pay the mortgage? That has to get paid. Hopefully, a family member or someone else is willing to loan the estate money with the understanding that once the property is sold, they'll be reimbursed. But it can be difficult if there is no source of funds. Borrowing against a house and held in an estate or a trust is very difficult. It's not like borrowing against a house at a personal residence, which is much easier to finance. So it can be complicated if most of the assets are held outside of the estate because they were either joint or with a beneficiary, and we have a large property that's subject to not only a mortgage but property taxes, utilities that need to be kept up. It's December and we can't have the water's on, you have to have the heat on. So it can be difficult under those circumstances. Actually, it can be difficult under just regular circumstances, but that makes it a lot worse.
And I would just say, 2 words of reassurance I try and offer my clients in the probate process in this situation is, one, a personal representative is not going to be personally liable for the debts and obligations of the person who's passed away. In other words, if there's a mortgage on a house, just because I'm the personal representative of the estate, I don't suddenly become personally liable on that mortgage. Now, I have obligations to try and make sure that mortgage is paid, but I don't become personally liable if the decedent had a credit card. That's a very typical situation. I don't become personally liable on the decedent's credit card just because I'm personal representative of the estate. The second point that I often try to get across to my clients is probate's going to be a really foreign territory for you. For banks, for other institutions, it's not their first time at the rodeo. They have dealt with these cases before. Every single day they're dealing with this situation. So there are, most large lenders and mortgage companies have entire departments that are set up to deal with this. And they will, in my experience, most will work with an estate. Now, they may be very anxious for you to get that property sold, but I try and reassure folks that it's not going to be a situation where if you can suddenly make another $3,000 mortgage payment because you have your own mortgage payment for your house, everything's going to fall apart.
Okay. Well, let's say that you do have to make some personal payments on some of the debts of the estate. Reed, what documents do you want to make sure that you're keeping and keeping in an organized fashion that you may need to use later?
I would ask my client or the person representative to make sure that they keep every financial record that involving the estate.
Every last shred of paper.
Absolutely. I always say, bring in everything you have, keep everything. It's much, 3 years from now we can get rid of it all, but for now, keep everything. It's not just, you may have to prove to the creditor that it was paid. They may, yes, you paid it, the estate paid it. You may have to prove to a disgruntled beneficiary that you made that payment. We may have to prove to the Internal Revenue Service that you made that payment. There's all kinds of different people who you may have to document payments, income, any other financial transaction. you are responsible. You are we call a fiduciary. You have a responsibility to creditors, beneficiaries, anyone who has anything to do with this estate. So it is in your best interest to make sure you have every piece of paper you can.
Well, not the least of which being the Register of Wills. The personal
True.
representative during the probate process has to file periodic accountings with the Register of Wills. In most estate administrations, I should say, there is a carve-out for something called modified administration. But in most probate estates in Maryland, the personal representative has to file periodic accountings. And you better believe that the Register of Wills has an entire department that's set up to audit these accountings. And you have to account for pretty much every cent in and every cent out of the estate. And you have to have backup documentation to support that. So, there's got to be invoices, there's got to be bank statements. You really do have to document it because the Register of Wills really does have a lot of supervisory power and authority over personal representatives in the course of their estate administration.
So let me ask you, Reed, if you're the personal administrator for an estate and you're their fiduciary, can you ever be held personally liable?
If you are the fiduciary and you are taking money from the estate and filling your pockets and taking off for a island vacation, absolutely. You have a responsibility to the beneficiaries and the creditors. So you can't use the money for yourself. You can't use the money even if the plan was, things got tight, you were just borrowing it for a week. It's not your money. It never is your money. Under no circumstances can you use that for personal needs.
And the one other important point where personal representatives can actually be held personally liable is to the Internal Revenue Service and the state of Maryland comptroller. And that would be a situation where the estate has tax obligations, or the decedent, the person who passed away, has tax obligations. And the personal representative starts distributing funds from the estate, and suddenly the estate has no funds, doesn't have sufficient funds left to pay the tax obligations. Well, the IRS, the comptroller, they are going to come. That is really the one situation where even just by administering an estate in the ordinary course, a personal representative can find himself or herself personally liable. So, oftentimes we will do checks, and there are ways for a personal representative to actually obtain the tax payment history of the person who passed away to make sure that that's not a snake in the weeds, because that can really, really come back to haunt a personal representative.
Now let me ask you, gentlemen, when you're first opening an estate, most people have seen wills that are pretty generic, that talk about my estate goes to my 3 lovely children. How do you find out what assets and what creditors or debts are actually existing?
Well, I'll jump in and you fill in any of the big gaps. I'm sure will be there. So, first off, a lot of times clients come in and they've seen movies where there's a reading of the will, and that at least in Maryland is a work of pure fiction. There is no reading of the will where everybody comes around the lawyer's office and you read the will. I suppose folks could do that. Certainly not required in Maryland. Now, if you're the personal representative, how do you figure out what assets and liabilities the decedent has? Well, one of the ways that you can do it, and it's a very practical matter, is use mail forwarding and monitor the person's mail for statements of account from banks, from invoices from creditors, for past due invoices. But of course, a very complicating factor is we're in a digital age. A lot of us have electronic bills that come to our email. So Maryland does permit what are called digital assets. So the personal representative can often access the email of the decedent, and that's another way that you can locate assets, because for many of us, we simply don't receive paper bills anymore. It used to be that you could tell somebody, with pretty good certainty. Just set up mail forwarding, and within 30, 45 days, you'll have a pretty good idea of all the accounts that are out there and the liabilities. Not so anymore.
Reed, what happens if you miss one of those people?
An asset?
Either an asset or a liability.
Well, as far as liabilities are concerned, secured liabilities that we talked about earlier, car loan, mortgage, those, because of the risk of losing the underlying asset, the secured asset, those you want to be very careful about, but you will receive very quickly notice if those payments are missed. General creditors have an obligation to file a claim with the Register of Wills. Their obligation is, they have a window, 6 months from the date of death of the decedent, to file a claim with the Register of Wills in the county in which the decedent was domiciled. So while you want to keep track of the claims and other debts of the decedent, the creditors have an obligation as well
Okay.
to notify the personal representative and or the Register of Wills.
Okay. Thank you very much. Unfortunately, we are out of time. I'd like to thank our guests, Jeremy Racklin and Reed Spellman, for taking time to discuss probate. If you want to know more about me or either of our guests, please look us up on our respective websites, www.jdcats.com for Jeremy Racklin and www.jgllaw.com for Reed Spellman and me. Let us know what you think of the show and what topics you would like to see covered in future programs by emailing us at lawschoolforthepublic@gmail.com. Please join us for future shows in our Law School for the Public series, which explore various and timely legal topics. On behalf of the Bar Association of Montgomery County, we look forward to being with you again. I'm Ann Grover. Thank you.